I wish you all a very happy new year. Welcome to 2026.
Adjournment request, if any, from item number 1 to 4. From item number 5 to 15, adjournment request.
Wait, please, my lord. Item number 3 and 4, my lord. I've taken consent of the respondent, my lord. Can it be taken after the Bihu vacations, my lord? 3 and 4.
These are for orders, no?
Order matters.
So it can be done, no? No argument is required.
Okay.
Let's see what's the matter.
From item number 16 to 25, adjournment request.
May I please, Lordship? I beg to mention item number 22, Lordship.
Yes. Yes, what do you want?
Yes, maybe after Bihu vacation, Lordship,
Maybe after Bihu vacation.
if possible.
As you are appearing for whom?
I am appellant, Lordship.
As prayed for on behalf of the appellant, re-notify. February must be.
Obliged, Lordship.
6th of February.
May it please your lordship, I beg to mention item number.
Just a minute. Have you informed the other side, Mr. Advocate? Have you informed the other side?
No, Lordship, I will inform, Lordship.
No. The order shall be signed only if you come and tell us that you have informed the other side.
Obliged.
Yes.
May it please your lordship. When I beg to mention item number 25 on behalf of senior counsel, Mr. Lalram Zawama. He is from Aizawl. But there was no fixed date and there's some difficulty today, my lord. Would it be, my lord, if lordship permits, after the second week of February, my lord?
He's appearing for which respondent?
My lord, item 303 respondents, my lord.
He is appearing for the private.
Private respondents, my lord.
As prayed for on behalf of respondents and agreed to by the council for the appellant. Let this matter come up for consideration on so date sometimes in February.
My lord, a fixed date if lordship.
16.
My lord,
16 February.
16. Deeply obliged.
Will be towards the end of February, my lord, subject to convenience.
You are appearing for the
I'm for the appellants, my lord. My lord, there is an-
27 February.
accommodation, so we will
My lord, sure,
accommodate
sure.
him also.
Sure.
Otherwise, he will not consent.
Surely, my lord.
I'm grateful, my lord.
27
Deeply
February.
obliged.
Interim order, my lord, that may be continued, kindly.
If you are not passing any order vacating the interim order, it continues, no?
It continues, yes. ma'am. Obliged, deeply obliged.
From item number 26 to 32.
May I please your lordship? Lordship, I beg to mention item number 26, lordship.
Why?
Lordship, here the private,
Pension, second wife's pensionary rights.
lordship, the private respondent, Mr. D. Das, he is unable to appear here today, lordship.
Now let's see what the appellant has to say.
Lordship, we have already informed them, lordship.
You have informed them. Can we say as jointly prayed for?
Yes, lordship.
No, we will not say that. As prayed for on behalf of the respondent, after having obtained consent from the appellant. List this matter on. It goes in February then.
23rd February.
Yep.
Any other request? Daily list for orders item 1.
There is some request later.
Lordship, I beg to mention a matter. It's for an urgent writ petition that we have filed in Saturday. It's with regards to this property in which the respondent bank has taken hostile possession prior to the pursuant to the filing of the writ petition. It's a prime property located in GS Road.
So
So
what is going to happen? If the possession has been taken, it can be restored by the relevant court,
your lord,
DRT, DRAT, whichever.
you're right, your
I
lordship.
think you'll have to withdraw the writ petition.
If I may
You
just
move
add,
for the appropriate forum. That's the matter is urgent, no doubts. But then now the possession has been taken.
your lordship, herein in this,
And it is not hostile possession. Possession has been taken.
your lordship, actually there are already stay orders passed by the DRT and this matter is sub judice before
So
the
go to
civil court.
DRT. No writ petition would lie.
It's actually,
Even if it lies, we will be loath in passing orders.
I understand your lordship, actually this property is also undemarcated and it's also pending before the civil
That
judge.
cannot, that is a ground which you can raise before DRT or DRAT as the case may be. I don't think so. You'll have to withdraw. That's a misadventure in coming to this court. Why do we list it? Huh?
Considering there are two forums involved
Look,
here,
we
hence,
will bring it on record. But after 2 minutes, don't waste more than 2 minutes of the court. Withdraw it.
I'll do so, your
And
lordship.
we will give you the liberty to approach the DRT.
I'll do so, your lordship.
Tomorrow.
If the matter, as an early item tomorrow, your lordship, in that case, if I may request. As an early item tomorrow, if I may.
Tomorrow it shall be listed. What early?
Much obliged.
But be ready for withdrawing the petition. Right? We'll see the petition. If there is any possibility of relief, we will consider. But otherwise, no. Yes.
No, sir, I have informed the understand.
All right.
Obliged.
Daily list for orders item 1.
क्या किया?
No, it's correspondent.
You're not interested.
My lord, presently we are not in this matter, my lord. We have already returned the brief to the client, my lord.
What is your name?
I am appearing on behalf of Mr. B. Pathak. My name is V. Kumar, my lord.
Mr. Kumar, learned advocate, appearing on behalf of Mr. Pathak, the advocate on record, submits that the file has been taken away from the office of the conducting lawyer. And perhaps for that reason, no steps could be taken for issuance of notice to the respondents. It appears that the petitioner has also not taken any interest in pursuing this matter. In all its probability, the petitioner appears to have lost interest in prosecuting this case any further. Dismissed for non-prosecution.
Deeply obliged.
Item number 2.
Yes,
But review is still pending, my lord.
My lord, in this regard, my
for eternity.
Sorry, my lord.
You will keep it pending for eternity.
No, my lord. It has not been listed, my lord.
Who ensures that it is listed?
Right.
Have you made a mention before the concerned bench?
Because
Have you filed any slip before the registry? Have you mentioned before the concerned bench?
earlier I have filed, my lord, but recently I did not know.
Take steps for its listing, otherwise we
Yes.
initiate the contempt petition.
my lord, petitioner is suffering, my lord,
We
from
understand. that.
cancer, my lord.
Mr. Khatniar,
Yes.
you can't hide behind the shield
Yes.
of review.
I'll immediately take step for listing, my lord.
By what time should I place it? On that day, you will not say anything. You will just answer to the charge of contempt.
Last week of January, my lord.
Now we give you first week of February
Yes, my lord.
as prayed for on behalf of the estate. And as prayed for on behalf of the state, let this matter come up for consideration under the same heading on, give a date in first week of February.
Obliged.
Get it listed,
Yes, my lord.
get it decided, otherwise comply with the order.
Yes, my lord.
Obliged.
6
Obliged.
February. Item 3 and 4.
You want a time, what is it? You want a time in this?
Yes, my lord. There are two matters. My friend is appearing in item 3. There's another matter, item 4, where notice has to go upon the private respondent, my lord. He is not appearing in item.
Lordship, my name is shown as a counsel for the respondent 5 mil, but in fact, there is a separate petition. I have no instruction, my lord. 1737 million. 2023.
Otherwise, we'll see it. Let it come for admission.
Yes, ma'am.
Let the pleadings appear to be complete in both the writ appeals. Let both the writ appeals be listed for admission on. We have a date in the last week of February.
23rd February. Item 5.
Because he is complete 147, but none here. Or if it is effective, it's a
Nobody has appeared on behalf of the applicant to press this petition for condonation of delay. Press this application for condonation of delay. The application is just dismissed for non-prosecution. Not on the first day. Like, nobody appears on behalf of the what? Nobody appears on behalf of the applicant to press this petition, press this application. Re-notify February 1st week.
9 February. Item 6.
May it please your lordship.
Awaiting the service of notice
Upon
and appearance of respondent number 10, the matter is adjourned to February number 12.
Oblige.
2nd March. Item 7.
Wait, please, your lordship.
क्या है?
On the last occasion, the response took time to file the objection in the matter.
Yes, have they done so?
Wait,
no,
please,
not yet.
Lordship, Lordship, we have received the instruction. I would like to pray for 1 week time, Lordship.
You should have said that in the beginning, no? There's an order which you must comply. You should have complied by now. All right, as prayed for on behalf of the respondent, list this matter on so and so date.
Oblige.
Oblige, your lordship.
25 February. Item 8.
Report regarding service.
My lord,
Who is respondent number 1 here?
my lord, as per office note, service is not waited.
Who is, I am asking, who is he?
Settlement holder, my lord.
Like here, awaiting the report regarding service of notice on respondent number 1, the matter is adjourned to so and so date.
2nd March. Item 9.
Okay. But why under orders? Let this matter come up for admission on which day you want?
Any date, my lord.
No, tell us the date.
After reopening on Bihu, my lord, 19th.
Acha, nobody appears on behalf of the appellant. Mr. Kane Chaudhary, Leonard Senior Advocate, is present. For appearing for the respondent is present. Respondent number? Now you're here.
Actually, I am appearing on behalf of Mr. Dinath. Dinath is on leg. Lordship may kindly adjourn the matter for the time or allow us 5 minutes. He's just coming.
Inform Mr. Nath that this matter has to come under the heading admission.
Yes.
Can be dealt with under orders. We can do that, but not today. Okay. This matter ought to have been listed for admission. List this case for admission on
19th, my lord.
19th.
Yeah, but
Inform your senior that 19th is the date when he should be here.
I'm sorry. I've come.
But Mr. Nath,
Can I do it?
no need to be apologetic, but the court wants to tell you something.
No, no.
You need to mentor your juniors.
That's-
How to take time, what to say. I think that's very necessary. Unless you people do that,
No.
the bar would deteriorate.
No, I'll take
It's
care.
not her fault.
I'll take care of.
Now she came late. Then she says, actually, I am for Nath. That's not the way. You have to let her know she's a young counsel. How would she know unless you tell her?
True, my lord.
Now you people take work from the juniors, you don't train them.
No, no. Sorry.
No need to be sorry. I am just reminding you of your
No,
obligation towards the younger members of the bar. Therefore, I did not say anything to her. She would be in a quandary. What has picked the judge? Nothing. We are not angry or something.
no.
That's not the way time is sought.
No, Lordship, I'm
All.
sorry, my lord. I'll take care of it, Lordship. No,
Yes.
no, no.
Item 10.
May it please the lordship.
What is Mr.
Accountability matter, there is
Your first name, right?
elected three,
Yes.
page 33, my lord.
What is it?
That is page 33, my lord. Operative portion, my lord, page 39, my lord.
Page 39.
Yes, my lord, case link case number 4942. And my lord, operative portion, my lord, page 43, my lord. Considered opinion, the para 9 and 10, my lord.
And what is the ground of challenge?
Ground
Ajay, this is a contempt order.
content, my lord.
Let notice be issued, sorry.
Madam.
Let notice be issued to respondents number so-and-so / proposed contemners on steps being taken by the petitioner within a period of 2 weeks, both modes returnable March 1st week.
Mark.
6 March. Item 11.
Same order. Same order.
Obliged,
Date
my
would be different or maybe the same.
obliged, my lord.
36 days open on.
Item 12.
Dusty, yeah.
Actually, your lordships pass over the matter for the time being.
Pass over the matter for?
That time being, your lordships.
Who has asked you to take time?
Senior advocate, Mr. R. Sharma.
No, Dusty affidavit has been filed. It appears that no Dusty notice has been served upon the respondents. Have been served upon the respondents number 1, 3, and 4. Let Dusty notice be served upon respondents number 1, 3, and 4 within a period of 1 week, failing which this application shall be dismissed without further reference to the bench. Oh, you have taken
Yes,
taken
your
steps,
lordship, it's
but
under process.
where is the proof of your having taken steps? Anyway, pass it over. You ask your senior to
Yes,
be
your
here.
lordship. Obliged, your lordship.
Item 13.
Office note. Lordship, may kindly produce the office note dated 22/5/2025.
What is it? Tell us.
Lordship, the service has been deemed to be complete by the Labazama court and the matter has been placed before your lordships. 2/9/2025. The order is of 2/9/2025.
Let this matter come up for consideration under the heading admission on so and so.
Lordships. Deeply. Lordship, kindly
give the date.
fix a date.
Yeah.
24th February.
Yeah, when I don't spell out the date, you can take it from the court master.
I'm deeply obliged.
Item 14.
24th of February.
12-43 days.
No,
First time. You have to take steps by both modes.
I had taken steps, my lord. Now the report says that, my lord, that it is not reserved, my lord, returned back and neither received.
No.
And I have usual process, my lord. And my lord, I
You
am
have not
told,
taken steps by usual process.
I had taken steps as per the direction of the court, my lord.
What did the court direct? Fresh notice to be issued
Yes.
on steps being taken so and so by registered post as well as usual process.
Yes.
Usual process, they say you haven't taken steps.
Yeah, legal step, no. We had taken steps, my lord. To my information, I had been intimated, my lord, that we had taken steps. I don't know.
The office note dated 22nd of December 2025 says that no process has been taken, no steps have been taken up.
My lord.
1 week further time is granted to the land council for the applicant for taking steps for issuance, for taking usual steps, for taking usual process, for taking steps under the usual mode for issuance of notice to
My lord,
response number 1.
May I make a small prayer, my lord? My lord, can this notice by usual mode can be directed through the, my lord, CJM of Banaras, my lord?
Why?
Because I am told, my lord, that, my lord, they are avoiding the service of summons for the intentional.
You tell us then.
Yes,
But you take steps and then how can you say that they are avoiding? If you have not taken these steps.
Because the registered
Sorry,
steps.
one further week is given.
My lord, I'm okay.
Returnable sometimes in March.
9th March. Item 15.
That should be done.
May I
Like,
please, Your
Accountant General
Yes.
unnecessarily.
I quite see that now. As a major abundant caution, we put the accountant general assent. But they have filed, they have nothing to do, they say.
To the application
I
having
think a
been
lot
filed,
can allow this.
pursuant to the application having been filed for deletion of the name of respondent number 4 / the accountant general, bracket A and E Assam, Maidam Gaon, Betola, Guwahati, comma, the land council for the applicant. Yeah, application has been filed by the respondent.
that's one number 4.
The land council
That's
for
what
the
number
applicant,
4.
the land council for the applicant agrees to and deletes the name of respondent number 4 from the array of parties. Stop. Necessary correction shall be made in the memo during the course of the day.
My lord, I am appearing for respondent number 8 matter. Actually, for some time, I am going.
We are adjourning the matter. Let this matter come up for consideration in usual course, preferably on first week of March.
Obliged.
Item 16.
Make necessary correction and
Yes,
counters. I will sign it in the.
yes, they will do that.
I'm not asking you. You're
No, I quite see that. Obliged.
Item 16.
This appeal has been preferred by Union of India, my lord. And in preferring the appeal, my lord, there is a delay of 85 days by DFF authority, my lord. They have to take instruction from the higher authority that subsequently legal opinion has been
This,
taken.
right?
85
Yes,
days.
what do you have to say?
Is this aviator, my lord?
My lord, 86 days delay, my lord. There is no sufficient cause, my lord. Explain.
Respond.
Explain, my lord.
You want to respond to this application. We are inclined to condone the delay.
I may submit the oral, my lord, oral submission, and I will submit to decision of the Honorable Apex Court, my lord, in this regard, my lord. May.
Decisions.
Grounds we have mentioned in paragraph 3, my lord, page 5.
Well, in this case, my lord, the 86 days delay is, my lord, it is an inordinate delay, my lord, and this Honorable Apex Court held that.
All right. All right, delay condoned, the application stands allowed to appeal to be processed. Heard so and so.
I am obliged, my lord.
Item 17.
May it please your lordship. My lords, this delay application is occasioned because this is the second round of writ appeal. If your lordship just have a look at 117, first writ
This
appeal,
item number?
17, my
This is
lord.
item number 17.
My lord.
What it is? It
My
is
lord.
for condonation of delay of 907 days.
My lord, that is only because we had preferred a writ appeal on the earlier occasion. If your lordship sees that 117, because of certain development that was disposed of with liberty to file a fresh appeal.
That's all right. But still notices have to go, no? Mr. Bot.
My lord.
It is just, my lord.
We have not been served with a copy of the interlocutory application. My lord, 907.
How is that possible, Mr. Goswami?
My lord, I will.
My
I will coordinate, my lord. I will coordinate. I will coordinate.
Serve him a copy today,
My
tomorrow.
lord, I have already served just now.
So we condone the delay.
Yes.
My lord, that is-
907 days, my lord.
But reason, you see the reason, no? If you want to put in your written objection, you can do so. But then you know our views.
My lord, my lord, my
Same order. Delay condoned, application allowed, process ready to be processed.
27.
Opposes vehemently. लिख देते हैं, Mr. Borpuzari, you opposed vehemently.
27 February. Both of us.
Deeply obliged, my lord.
For admission, item 18 and 19.
The last occasion by order dated, your lordship order dated 19/12/2025, my lord. My learned friend, my lord, seek some time regarding instruction, my lord.
No,
Yes.
that has been rejected, no? The government has rejected it or it's still under consideration?
lord. My lord, it is still under consideration because of the reason, my lord, that it will entail, my lord, huge financial implications. Because if it is switched from, my lord, NPS to OPS, number one. And number two, in the
Why are you considering it? It's a date-based, benefit. Yeah. So if you say that you're considering it, why are you talking about all this, that it will cause huge financial burden to the state? You have undertaken to consider it.
Now, my lord, in that view of the matter, if
The
lordship-
order is in your favor. The judgment is in your favor.
Yes,
So
absolutely.
whether, how are we concerned whether it is, it will cause financial burden to you or not? Especially when you are taking it into consideration that yes, it is not only the date of formal appointment, but date of initiation of appointment process. All this, it is no longer
Yes.
res integra. The issues have been decided.
Absolutely,
So
absolutely.
you have taken a call, you consider and reject
Yes.
or allow whichever.
So,
When do you want it?
so in that view of the matter, if lordship may be pleased to keep this matter pending for some time, my lord, at least for further 4 weeks, my lord. Let me have the, my lord,
As
today.
prayed for on behalf of Mr. Gaur Pujari, in order to take definite instruction as to the stand of the state,
My lord.
the matter is adjourned to give a date sometimes after Holi, no? After Holi festival. Kar lo.
Nice. my lord.
Item 20,
So obliged.
My lord, may I please your lordship, my lord, in this matter, it is PIL was against the blatant misappropriation of fund, my lord, at the panchayat level, my lord. On the last occasion, on 19th September, your lordship was directed to file them response, my lord, before issuing details notice on all.
Ask the standing council for PNRD to respond. It's a vague allegation.
My lord,
Today, we don't find any reason to entertain this.
my lord, kindly, my lord, I have given the details list of my lord. Where,
But here's Mr. Datta. No. Mr. Datta, but why have you not responded?
My lord, I am praying for some further time, my lord, and also some extra copies for the
But,
PIL.
we need to be told, why did we pass this order?
my lord, I have given the list of 100% money where, my lord, they are misappropriated.
These are vague allegations, but nonetheless, you respond.
My lord,
Mr. Datta.
and my lord, what they are doing, kindly, my lord, once again, my lord. My
We are inclined to dismiss it. We are only adjourning the matter for the reason that we have earlier passed an order that he should respond. Please don't argue further. Let him respond. Mr. Datta, learned standing council so and so submits that he shall be responding to the petition by the next date with a copy of the affidavit served in advance on the council for the petitioner. First up, let that be done positively on or before the next date. Re-notify on so and so.
12 March.
My lord, I'm also praying for some extra copies of this petition.
Give it.
Highly obliged.
Item 21,
Yes, Mr. Nayak.
Lordship, in this case, petitioners are praying for construction.
No,
of
that
a-
we know.
Yes.
There is an order.
Yes, in terms of your lordship, last order, lordship, I have already received instruction and I have also sent the affidavit for betting. But what I can inform your
Nayak,
lordship at this stage,
Mr. Nayak, learned additional advocate general Assam submits that instructions have already been received for filing an affidavit in response to the petition. And the response affidavit shall be filed by the next date. Re-notify 2 weeks.
lordship, oblige that.
ऊपर में लिखना, nobody appears on behalf of the petitioner. However, Mr. P. Nayak submits so and so.
Oblige.
25 February. Item 23,
Wait, please, your lordship. Well, I have received the instructions from the deputy commissioner. The land which is sought for by the bank, well, that is described by them as periodic patta, Khiraj Miadi. But according to the records, it is T-periodic patta.
Yes, your lordship, we have also clarified that. It is an T-periodic. Then your lordship, as far as section 14 is concerned, that the duty of the magistrate is the ministerial. So he has to,
That's all right, but you have to answer the questionnaire, no?
yes, sir.
It's a tick box exercise. There are 14 items which you have to respond.
Yes.
Without that, they will not proceed.
Yes.
Have you done that?
So your lordship, yes, I may be allowed some time. I'll place it before your lordship.
As prayed for on behalf of the petitioner, re-notify.
Meanwhile, I'll file my affidavit. Lordship.
That is there, your
In the meantime, Ms. Sharma. Ms. Sharma, let counsel for the respondent shall put in the affidavit, the response affidavit.
Obliged.
26 February. Item 24.
May I please your lordship?
कहाँ से रेट कैसे ऑर्डर करेंगे? Against whom? President of Guwahati High Court Bar Association. Do you think writ is maintainable here?
Sir, I believe this is maintainable,
How?
Your Honor.
How?
Because there is a previous instance of the court order.
Previous instance of the court entertaining a petition does not make it entertainable.
Not petition, Your Honor. There was a notification issued by the registry of the Honorable Court regarding such a similar issue.
Mr. Das?
Yes.
You are appearing for High Court.
Yes, Milord.
So is this maintainable?
No. In my humble submission, Milord, Bar Association is not a state. There is a
No, that idea has been diluted to a large extent after that case, no? That case Puttuswamy. Now, the maintainability is on the ground of public duty. It's no public duty. Is
no public duty, Milord. And it's always on account of availability of space.
If it is not maintainable, it is not maintainable.
Yes,
We will not
true,
enter into the merits of the case.
Yes, true, Milord.
You charge fee, license fee, you charge welfare fund from the advocates and you don't provide even a chair.
Milord, I
But
don't
then
charge,
can
the
I-
Bar Association charges.
That, I mean,
Yes, Milord.
because I don't think so.
Your Honor, my identity card issued to me by the Bar Association, it has the signature of Registrar Administration. That's how I am trying to make them a party to this case.
You are trying to make them a party, but we are trying to find out how to dismiss this petition because it is not maintainable in our estimation.
Your Honor, please give me another date so that the parties can enter an appearance and provide their written.
We give notice, we issue notice to the bar president. We are not unnecessary issues of notice, though it might appear to be innocuous step by the court.
Your Honor, I could have approached
Don't
the.
allow the court to complete the sentence. Why do we hear you then?
I'm sorry. There is a judgment of Bombay High Court, Honorable Bombay High Court.
You require a judgment for this?
No, I don't require, even then your lordship satisfaction, Milord. I'm sorry, Milord, somehow one copy has come only. I'm beg apology. Otherwise also, Milord, it's settled.
Tell us what do you want?
Your
This matter
Honor.
would- Try and understand.
Yes.
We are absolutely sure that the parties, the respondents are not state within the meaning of Article 12 of the Constitution, and therefore no writ would be maintainable. So would you want this dismissal or would you talk to the bar president to give you something?
I have already asked for his
Anyway, then we are-
response through a letter. He did not reply. That is how the case has come to be.
This is the petition.
He could have replied to my representation, Your Honor, please.
Do it. Withdraw and do it.
No, he could have replied. I have already
Acha, he could
given
have
a
replied.
representation to him.
That only when there is a public duty.
Your Honor, this not only affects me as a person.
If you file a case in some other forum.
No, Your Honor, please listen to me. This issue, it not only affects me, but people similar to me, people as in the newcomers. We do not know where to go. We are running from pillar to post,
Is
Your
it a
Honor.
public interest litigation?
Yes, but then it involves only the advocates. That's why it said a writ petition.
No, is it a public interest litigation?
No, I said no, because we are advocates that are involved in this matter. So that there could not have been a PIL.
But without maintainability, without it being maintainable, would we doing the right thing of issuing notice to the parties?
Your Honor, at this stage, I would not go too much into the details. I would like to hear them what they have to say before the court, because they are not replying to me. I think the authority of this court will persuade them to reply, give a decent reply in a written
Can
form.
this be a forum for, bringing them to books?
Not bring them to books because they are not criminals. But then what I'm trying to say is,
Always arrest.
Your Honor, I leave it upon your good judgment, but I would really like to see their answer in a written form.
Go before the authorities, go before the respondents, they will respond. They are not passing any order.
At least notice, Your Honor.
Not at all. You can use it you can wield it as a, what do I say, as a stick to them, that, well, I will be pressing this writ petition unless you respond to my request. You can take an adjournment, we can grant you adjournment because you are a lawyer and today being the first day, but we are inclined to dismiss it. We think it's a case for dismissal.
Please adjourn the matter for the day.
For the day?
As in till they give me a reply, until I approach them in a proper way.
That is not possible. As prayed for on behalf of the petitioner, let this matter come up for consideration sometimes in March. In the meantime, you take the response
Discussion.
of the Bar Council, Bar Association President.
Okay. So much obliged.
18 March.
Deeply obliged.
There is nothing to feel obliged, no? We have not given you any benefit.
Yes.
We would like you to be given a seat.
Yes.
But the only problem is that we can't pass an order in this petition.
Yes.
And how did it come before division bench?
There is a notification wherein the Registrar General is a party and the petition.
Why have you made Registrar General a party?
Yes.
Why?
Because his signature appears on my identity card, first of all.
Is that the reason why you impeded?
No, and the second reason is the notification that I have relied upon to show that there is a previous instance.
I don't think so.
That was a notification.
If you delete the name of the Registrar General, we might consider. We might pass an innocuous order asking discussing about the maintainability of the case, we might say, but no Registrar General.
Okay.
He has no authority otherwise.
Yes.
To provide you a seating arrangement. On next day, either withdraw the petition or delete the name of the Registrar General from the area. Yes.
Possible matter 12.
Yes, madam.
Please, ma'am, my lord, we were trying to take justice service in this matter. One office of the respondent number 6 is in Kolkata, one is in Hyderabad. So we could not serve any service to them. My lord, as a last resort, my lord may be pleased to let us issue a paper publication, my lord, one in Kolkata and one in
File an
Hyderabad.
affidavit that it is not possible, even though there was an order.
My lord.
On that affidavit, we'll pass an order.
My lord.
Let this matter come up for consideration. At the request of the Land Council for the petitioner, let this matter come up for consideration on give a date immediately after reopening of BO.
6 February.
Oblige me, lords.
Item 27 for admission.
May please your lordship. My lord, the petitioner was aggrieved by an order. My lord, may I take your lordship to the order which was challenged before the honorable single judge?
Now let us see the impugned judgment.
My lord, the impugned judgment is at page 67. That has been, my lord, on the basis of another judgment. Page 67 is the order passed in my case.
Page 67.
67, my lord, 67.
Yeah.
11 part at page 68.
Just a minute. Give us a minute. Now, where do we find paragraphs 13 and 14 of the judgment dated 3/5/2024?
My lord, that your lordship will find, my lord. It starts at page 97.
Yes, where is it?
The, my lord, judgment starts at page 97, my lord. And the relevant paragraphs, the lordship will find.
Paragraph 13 and 14, what does it say?
110. 110, my lord.
Page 110.
My lord. Paragraph 13, it is further made clear that any rights accrued to the appellant's reputationers under the provisions of the Service Order 2006 and the Service Amendment Order 2010, such as seniority, pay protection, promotion, etc., of the respondent shall grant the reliefs.
That's all right, but that's not on the merits, is some other paragraph.
My-
And then this order has the approval of the Supreme Court.
My lord.
SLP has been dismissed.
My
It
lord,
appears.
my lord. My lord, my submission before lordship is that if your lordship kindly comes, my lord,
No, but why?
my lord.
Tell me, Mr. Chaudhary, why after this order by the Supreme
My lord, in fact, my lord,
affirming the judgment of the division bench,
my lord.
and now where is the scope for us to review it?
My lord, if your lordship, my lord, saying it is a reversion from my lord the LDA to surveillance worker, and the basis, my lord, basis of this order, my lord, the order which was, my lord, issued by reverting me, that was on the basis of an order of the honorable single judge at that point of time, my lord, Justice Ujjwal Bhuiya. That order, your lordship.
Take the
No, no, my lord, I'm not. I'm sorry for that, my lord. That if your lordship kindly peruses that, that cannot be a basis of the order of my lord. These points have not been, my lord, urged.
No, no.
These points have not been urged before.
That's over. That's over, huh?
If your lordship kindly peruses that order,
No, but you should have objected to the order dated 9/1/2025 that
my
it
lord,
is not
I agree, my lord, that was not there, but the petitioner is
Now, Mr. Chaudhary, there is nothing in this.
only one consideration. If your lordship, my lord, looks
We
at
can't
that,
go, especially if had it been only division bench's order, we would have agreed to. But once it has been upheld by the Supreme Court, we would be crossing the line.
my lord, these are not urged before the, my lord, either before the single judge or before the.
Do we need to remind you that it would be deemed to have been argued and rejected?
True, my lord. True, my lord. It's
After
only
because
because the orders that was passed on the
Are
basis
you,
of
are you
equity.
agreeable to withdraw, or we refer to the Supreme Court and we dismiss? That's your choice.
Only prayer, my lord, your lordship will kindly peruse.
We have heard Mr. M.K. Chaudhary, learned senior advocate for the appellant, and Mr. B. Gogoi, learned additional advocate general assembly.
Yeah.
Stop. The challenge in the present appeal is to the order dated 9/1/2025, whereby the learned single judge has rejected the contention of the appellant on the basis of a judgment passed by division bench on 3/5/2024 in WA number 129 of 2021. The aforementioned judgment of the division bench has been upheld by the Supreme Court, as the SLP against the aforementioned judgment was dismissed in limine. It's a case of the reversion of the appellant from the post of lower division assistant to surveillance worker. Stop. The contention of the respondent / state is that the deputation of the appellant on such post was void ab initio. Stop. It was neither a promotion nor a valid transfer, and that the post on which the appellant was sent belonged to a separate cadre with no feeder post relationship and no provision for such conversion in the service fields. Regard being had to the fact that the issue was decided by a division bench and later upheld by the Supreme Court, there is no reason for for us to interfere in the matter on any count.
My
The
lord,
appeal-
I bow down, my lord, may I make a submission, my lord, because of the medical conditions of
The
the
appeal,
petitioner.
the appeal, that is something else.
Yes.
Therefore, I said that you withdraw, go before the authorities, ask Mr. Gogoi's clients to be considerate. Something can be done. We don't know. We are not going to tell you that. And you are unnecessarily closing the issue totally.
Because of the medical conditions only.
I think you have understood what we have said.
My lord,
If you want to do that, you don't take our approval, withdraw the petition and do it.
My lord.
So this is what I advised you. We saw that you want it for medical condition. You don't want to be a surveillance worker.
Because I cannot move, my
You
lord.
cannot move. So therefore, don't ask us to interfere. You're having the window closed in your face by your insistence of an order.
I wanted to, my lord.
After some arguments, Mr. M.K. Chaudhary, senior advocate, seeks permission to withdraw this appeal. See, this is also an indulgence which we should not grant.
My lord, your lordship will kindly
Subject,
grant me that.
I mean, Mr. Gogoi can object to it. That why after hearing and after dictating the order, why are you permitting this?
My lord, equity, my.
After some arguments, Mr. Swenso seeks permission to withdraw this appeal in order to pursue his remedies. In order to pursue his remedies before the appropriate forum.
My lord.
Dismissed as withdrawn with the liberty of court.
Let it be authority, my lord. Forum.
Forum ne authority.
Obliged.
This is, it may sound to be innocuous, but Mr. Chaudhary, you will go before the authority and say that the court has asked you to consider. That's really bad. I mean, situation is bad. I'm not saying your conduct or something.
My lord, I understand, my lord. I'm obliged.
For hearing, item 28 to 32.
Mr. Goswami is not appearing today. All right, you at what? Yes, Mr. Cook.
My lord, may I, my lord, request, my lord, this honorable court to have a look at the Assam Service Manual, to have a look at the service rules.
Yes.
My lord, page number 115.
Yes.
It is the, my lord, Assam Public Service.
1997.
1997, my lord. Lordship will see the definition, my lord. Rule 2, sub-rule A, appointing authority means the authority to whom the power of appointment is delegated. My lord, there here in the present case, my lord, there is no such delegation was made by the government or the director to the joint director. My lord. Now, Lordship, coming to the Constitution of Selection Committee, Lordship will find it at page 118, rule number 5. Constitution of Selection Committee. There shall be constituted different selection committee for selecting the candidates for class 3 and class 4 posts in different offices of the state for which no service rules or executive orders are in existence and are not within the purview of the commission as stated herein below. Now, my lord, A will be, my lord, for the present case, A, this will cover selection committee for the posts in the district level offices, divisional level offices, like those in PWD, forest, etc., and below district level offices. Composition of this selection committee shall be as under, my lord, there is 5. In the, my lord, selection process, there is hardly 3 or 4. Now, my lord, one more thing, my lord, rule 5, sub rule 3, page 121. It says the administrative department, that is the health department, shall issue instruction on the following, namely, the minimum essential qualification for direct recruitment to the post and the age limit of the candidate, minimum essential experience, if any, for the post or post, whether there will be written test, and if so, the name of the papers and the maximum marks for each paper, whether there will be typing test, and if so, maximum marks and of the typing test, and whether there shall be interview, and if so, the maximum marks for the interview. this was, my lord, never communicated, my lord, to the authority. So, my lord, nothing, no such instruction as per 5.3 was issued by the government or the director, who is the, my lord, otherwise the appointing authority. Now, 6.2 is very relevant, my lord. Rule 6, sub-rule 2, the selection shall be made on the basis of merit by taking into account the performance of the written test, typing test, interview with reference, my lord, this is very relevant, with reference to the mode of selection as laid down by the government instruction issued by the administrative department under the provision of sub-rule 3 of rule 5. Here nothing has been done, my lord. All these things have been, my lord, taken care of by the learned single judge while deciding this issue. Yes, my lord. And on top of that, my lord, rule 4, sub-rule 2, page 117, it speaks about, my lord, advertising the vacancies. My lord, in one case, in respect of one district, my lord, the advertisement was issued. In other district, my lord, no advertisement was issued. Yes. My lord, rule 4, sub-rule 2, advertise the vacancies, and it will have to be published in a newspaper, 2 regional newspaper, my lord, at page 118, clause D of sub-rule 2. Lordship will see, my lord, in case of Dibrugarh district, no vacancy was mentioned, my lord. And in case of Gwalpara, my lord, advertisement was, the vacancy was mentioned, my lord, but the newspaper, it was published also. That's what they say, my lord.
Gwalpara published, but in Dibrugarh, notice in the office.
Notice in the office without mentioning the vacancy. No vacancy was mentioned, my lord. Dibrugarh. Now, my lord, so far as, my lord, the judgments, my lord, otherwise my part is over. Well, they have relied upon 2-3 judgments, my lord. Just why I want to point out few paragraphs. It is in the red volume, my lord, writ appeal 428 of 2023, that convenience volume, my lord.
Convenience volume, my lord.
Writ appeal 428 of 2023. Page, my lord, 258 of the volume. It's Siraj Ahmed versus 258, 258.
Volume 2. Volume 2.
Isn't it? Yes, my lord, that one. In WA, my lord, 428 of 23.
Yes, volume 1.
Volume 1, my lord.
Volume 1.
258.
Yes, 258, my lord. The citation is, my lord, 2020 19 SCC 480.
Some problem with that.
Page number?
258.
Siraj Ahmed.
Yes, my lord.
कौन वॉल्यूम में निकल लिया?
प्रिंटेड है ये वाला ये
Okay. Okay.
Yes, we have marked it.
Lordship.
We have marked it.
Yes, my lord. Lordship, here, my lord, the entire issue, para 3 of my lord of that judgment at page 260. Lordship, you will see the facts, my lord. The facts giving rise to the present para 3. Present appeal are as under the appellant was appointed on ad hoc basis on the post of junior engineer in the pay scale of rupees so and so by order dated so and so issued by respondent number 1. It is not in dispute, Lordship is very important, my lord. It is not in dispute that the said orders was issued with prior approval of the governor of UP. In the present case, my lord, no approval, nothing, my lord. Even, my lord, the director was entirely in dark, my lord, about the selection. It is also not in dispute that the said appointment was made after the post was advertised so and so. So, my lord, this prior approval, my lord, I'd like to point out. And, my lord, in page 262, what was the main point, my lord, for which the entire selection was cancelled? That Lordship will find that it was for not having the prior consultation of the UP Public Service Commission. That was the only, my lord, lacuna in the entire selection, which the Honorable Court held to be irregular. But it was, my lord, entire selection was conducted with due approval or authority of the government, my lord. In the present case, that authority is missing, my lord. That's why I say, my lord, the very inception, my lord, the selection is wrong. And that's why the Honorable Supreme Court in Raghuveer Pal Singh has stated that it is a nullity. So that irregular, illegal, that part will not come, my lord, in the present case, my lord. And one more judgment, my lord, which they have relied upon. It is at page, my lord, 272. Pawan Kumar Tiwari versus Jharkhand State Electricity Board, 2025 SCC online, SC 1751.
Yes.
My lord, one para, my lord, page 277, para 23. Yes, my lord, this has been relied upon by the, my lord, appellants. I would like to point out, my lord, why this will not support them, my lord. Division bench appears to have blurred the distinction between the irregular and illegal appointment. In Vikas Pratap Singh Supra, this court has held that an appointment made without following every procedural formality may be irregular, but it does not become illegal unless it violates statutory provision. There is an apparent statutory violation in the present case, my lord. Or is made without existence. My lord, or part is, I'm not, my lord, relying upon. I'm regarding the violation of statutory provision. This
That's right, but it also says that if the appointment is to a sanctioned post made by a competent authority, you say it's not a competent authority and not tainted by fraud or deceit.
Made by, I've marked it, my lord. Again, my lord, that will be my lord, limp of argument that, my lord, it will have to be by a competent authority. In that case, my lord, it can be termed as irregular. This has been repeated in the subsequent para, in para 24 also, my lord. In this para itself, my lord, para 23, in the next page, the last line, it says, my lord, unless shown to be in violation of statutory rules. Again, my lord, in conformity to the rules.
No, I'll ask you to come to paragraph 35.
My lord.
That's the test.
Yes.
How do you cross the Rubicon?
Yes, my lord. I marked it, my lord. I will point out that line also. It must be underscored that the jurisdictional jurisprudential divide between the irregular and the illegal appointment is neither artificial nor academic. An appointment may be irregular if it deviates from established procedure, but it process in the realm of illegality only where it violates statutory mandates, my lord. That's the illegality. It will be under the realm of illegality only where it violates statutory mandates.
It doesn't say or.
But
it says
no,
if
it
it
says
crosses into the realm of illegality, only where it violates statutory mandates, number one, is made without the existence of a sanctioned post or. Achha, this is all.
My lord, the comma, my lord, these are three conditions. One, my lord, is violated, then it goes, my lord. Where it violates statutory mandate, or comma, is like it is made without existence of a sanction post, or is tainted by fraud. I will rely upon this part, my lord, where it violates mandate, statutory mandate. My lord, so far as, my lord, this item, my lord, 28 to 30. This is my humble submission, my lord. I have given the compilation also. Now, my lord, coming to the last case, item number, my lord, 32. That is writ appeal, my lord, 144/2024, which was slightly different from this 4 appeals, my lord. There, my lord, the issue was, my lord, lordship will take up a small compilation I have given, my lord. Writ appeal 144/2024.
Yes.
Judgments, my lord, will be same, my lord. Only thing.
Yes.
No, probably, my lord, that is of the, my lord, appellant side. My compilation is.
On behalf of the, yes.
My lord, I would like to, I have made my submission in para 1 and 2. But, my lord, lordship will kindly turn to page 8. Relevant page of the writ petition I have, my lord, enclosed in this particular compilation, just to show what was their contention before the learned single judge. In page number 9, my lord, para 3, lordship will see what is their statement, what is their pleaded case, my lord. The petitioners respectfully begs to state that the petitioners were unemployed youth and were in search of job. The petitioners came across an advertisement, lordship will mark this, my lord, an advertisement published in the local daily newspaper, wherein applications were invited for grade 4 post in the office of the Joint Director of Health Services, Shivsagar. The petitioners respectfully begs to state that the petitioners applied for the same. The petitioners thereafter participated in the selection process, and finally, petitioners were selected against the various advertised posts in the grade 4 cadre. I need not read further. Lordship will see the engagement letters now, my lord. Page 11, which they claim to have been, my lord, issued after a selection. Page 11. In continuation of this letter, it is so and so following workers who have been working as casual basis, my lord, as basis are hereby appointed as grade 4 in the so and so for, my lord, 3 months. How can a person be appointed? And, my lord, they claim that, my lord, they have been regularly selected by of a selection, which, my lord, is a blatant, my lord, lie. Every page, my lord, same thing. It has been extended for 3 months, for 2 months, and all of a sudden in 2011, they have been, my lord, regularized at page 118. So whether, my lord, they can be state to be, my lord, entitled for, my lord, such regularization in violation of the mandate laid down by the Honorable Supreme Court in Uma Devi's case, my lord, in para 52. Because, my lord, the Uma Devi's case is very clear, my lord, that one-time measure can be adopted till the who have completed, my lord, 10 years of continuous service and are working on a sanctioned post till the date of passing of the Uma Devi's judgment, my lord. That has been clarified in ML case. And only for those casual workers, my lord, other workers, that illegal and irregular part will come in, my lord, not for any selection. Here, my lord, in 2011, they have been, my lord, suddenly regularized without there being any policy. That policy came in 2013, my lord. By the state government, that policy was taken up. In terms of Uma Devi. So that's why, my lord, the learned single judge has, my lord, interfered. My lord, that too, my lord, they have not approached the Honorable Court with cleanness. They have stated that they have participated in a selection. There was an advertisement, select list, everything, but not a single, my lord, document has been annexed to the writ appeal or in the writ petition. To substantiate they are clear. Otherwise, my lord, judgments are same, my lord, in this particular case also. Yes, other case, my lord, without authority, the selection was.
Arguments heard, judgment is there.
May I just, I have just 2 to 3 points to just reply, Lordship. I'll be very short, Lordships.
Mr. Goswami, there is no reply to reply, but then if you're asking for, if you're insisting for, we will hear you.
No, if Lordship doesn't wish to, because I just wanted
why?
to point out certain.
It's no question of wishing to hear or not wishing to hear. If you think that it is necessary, we will hear you. Then you give him a chance. Then we ask him. Then we ask Mr. Gogoi, does he want to reply to what you say?
No.
It becomes endless, no? It becomes
Very well,
endless.
Lordships.
If you have something very important, tell us.
Yes, just one thing, Lordships. Today they are trying to, if Lordship will kindly come to their bullet point number 1. Their bullet point, that is what I just want to emphasize on only one point.
Yes.
Their bullet point number 1.
Yes.
They are now trying to justify the termination on 5 basic reasons. Number one, blatant violation of the rules. Number two, without having prior approval of the Director of Health Services. Number three, without approval of SLEC. Four, the advertisement was not published in a widely circulated newspaper. And five, the appointments were made during the ban period. These are the 5 basic reasons they have put forward. I asked myself, was any of these reasons in the show cause notice?
Yes. All right, anything else?
So they are now going much beyond the reasons for my termination.
Mr. Goswami, you have argued that.
And Lordship will kindly
You have
also have to
argued
look at
that, Mr.
Shripal.
Goswami.
Yes, Lordship. Shripal I did not place, I'm just putting it again. Shripal, which is the latest judgment on that.
We remember 3 cases by heart. Dharam Singh, Shripal, and the first one?
Jago. That is what has changed the entire landscape now.
All right, arguments heard. Arguments are heard. Judgment is given. Who's that?
I'm grateful.
Very grateful. Very, very.